5 seconds to go. Start. This section operates when in a trial it is proved that the offence has been committed with the consent or connivance or is attributable to neglect on the part of any of the holders of these offices in a company. Stop. In such a case, such persons are to be held liable. Stop. Provision has been made for directors, managers, secretaries, and other officers of a company to cover them in cases of their proved involvement. Stop. Para. The conclusion is inevitable that the liability arises on account of conduct, act or omission on the part of a person and not merely on account of holding an office or a position in a company. Stop. Therefore, in order to bring a case within section 141 of the Act, the complaint must disclose the necessary facts which make a person liable. Stop. Para. The three-judge bench also took note of the earlier pronouncements of this court in the case of State of Haryana versus Brijlal Mittal and others, wherein it was held that vicarious liability of a person for being prosecuted for an offence committed under the Act by a company arises if at the material time he was in charge of and was also responsible to the company for the conduct of its business. Stop. Simply because a person is a director of a company, it does not necessarily mean that he fulfills both the above requirements so as to make him liable. Stop. Conversely, without being a director, a person can be in charge of and responsible to the company for the conduct of its business. Stop. Para. The bench also considered the dictum of this court in the case of KPG Nair versus Jindal Menthol India Limited, which was also a case under the Negotiable Instruments Act. Stop. In the said case, it was found that allegations in the complaint did not in expires words or with reference to the allegations contained therein make out a case that at the time of commission of the offence, the appellant was in charge of and was responsible to the company for the conduct of its business. Stop. It was held that requirement of section 141 was not met and the complaint against the accused was quashed. Stop. Para. After analyzing the aforesaid and various other pronouncements, the three-judge bench in paragraph 18 of the reports, observed as under, para. To sum up, there is almost unanimous judicial opinion that necessary averments ought to be contained in a complaint before a person can be subjected to criminal process. Stop. A liability under section 141 of the Act is sought to be fastened vicariously on a person connected with a company, the principal accused being the company itself. Stop. It is a departure from the rule in criminal law against vicarious liability. Stop. A clear case should be spelled out in the complaint against the person sought to be made liable. Stop. Section 141 of the Act contains the requirements for making a person liable under the said provision. Stop. That respondent falls within parameters of section 141 has to be spelled out. Stop. A complaint has to be examined by the magistrate in the first instance on the basis of averments contained therein. Stop. If the magistrate is satisfied that there are averments which bring the case within section 141, he would issue the process. Stop. We have seen that merely being described as a director in a company is not sufficient to satisfy the requirement of section 141. Stop. Even unknown director can be liable under section 141 of the Act. Stop. The averments in the complaint would also serve the purpose that the person sought to be made liable would know what is the case which is alleged against him. Stop. This will enable him to meet the case at the trial. Stop.